Angela Bannon, Victoria Bannon, Professor John Williams and Dr Wendy Remans, Chair of the St Mark's College Board, Linda Matthews, other distinguished guests in our small in-person audience here at Downer House, and our much larger online audience, including online senior figures in the college, legal, academic, political and other communities. Ladies and gentlemen, let me begin by acknowledging the traditional owners of the land on which St Mark's College is situated, the Kaurna people, and pay our respects to elders past, present and emerging. We recognise and respect their cultural heritage, beliefs and relationship with the land, and we acknowledge that these are of continuing importance to the Kaurna people living today. Well, what a privilege it is for me as head of St Mark's College Adelaide to welcome you to the 2021 J C Bannon Oration, to be given by Professor John Williams on the topic South Australia and the Constitution, a mere provincial contribution, a title which ends with a question mark. And no doubt by the end of Professor Williams' oration, we will know if the question mark really applies. The J C Bannon Oration is one of the most significant events in the annual calendar of St Mark's College. It is given this year online, given COVID uncertainties. It's given in memory of Dr the Honourable John Bannon AO, the 7th Master of the College from 2000 to 2007, and before that, Premier of South Australia from 1982 to 1992. The second member of this college after Don Dunstan to be Premier of this state, and the second longest serving Premier of South Australia. John Bannon is remembered here at St Mark's with deep affection, respect and gratitude, not least for his intellect, integrity, warmth and grace. He is remembered for his lifetime of service to the wider community. Service is at the heart of the values of this college, and for his commitment to the benefits for students of collegiate education. In November 1961, when the schoolboy John Bannon was applying for a place as a resident undergraduate at St Mark's, his schoolmaster referee wrote to the Master of St Mark's a glowingly admiring reference for John, referring to John's imagination, initiative and enterprise, drive, independent thinking, and nerves of iron. The referee wrote, "He hopes to read law and then enter politics, and my guess is that he has a pretty good chance of accomplishing this." Well, indeed he did. The referee went on to say of John, "It would do him a world of good to come to St Mark's, and I hope greatly you can take him. I'm sure you wouldn't regret it, as he would certainly be a lively and active member of your community." As indeed he was. 38 years later, in 1999, after a most distinguished and wide-ranging career of public service, John wrote to the bursar of St Mark's College to apply for the position of head of the college. John wrote, "The college is an important and lively contributor to South Australia's academic life, and my contact with it both as an undergraduate and more recently makes me very keen to contribute to its development in the 21st century." As again, indeed he did. John's reference in 1999 to his then recent involvement with the college no doubt referred at least in part to the fact that, being a historian of the Australian Constitution and of Federation, including South Australia's role in it, John Bannon was the principal organiser of the Federal Convention Centenary History Conference held in April 1997 at St Mark's College. That conference marked precisely the centenary of the Federal Convention that met in Adelaide in March and April 1897 as part of the process leading to the Federation in 1901 of the Australian colonies as the Commonwealth of Australia. The 1897 Adelaide Drafting Committee for the Constitution of the new Commonwealth comprised Sir John Downer, twice Premier of South Australia, Sir Edmund Barton, who was to become the first Prime Minister of Australia, and Sir Richard O'Connor, who was to become one of the first Justices of the High Court of Australia. Sir John Downer lived in the house that in 1924 became the original building for St Mark's College, and this oration is being delivered in the ballroom of Downer House. During the 1897 Federal Convention, Sir Edmund Barton was staying in this house with the Downer family, and while there is some uncertainty about the extent to which the drafting committee of Downer, Barton and O'Connor did their drafting work here, there can be no doubt, I think, that some of the drafters' discussion took place in this building. Precisely a century later, in 1997, John Bannon arranged for Sir John Downer's grandson, Alexander Downer, then Foreign Minister of Australia, to unveil a photograph of the drafting committee of 1897. And that photograph of Downer, Barton and O'Connor hangs downstairs in the foyer of this Downer house. That photograph also appears prominently in the biography of Sir John Downer, Supreme Federalist, the Political Life of Sir John Downer, which John Bannon wrote and which was published in 2009. As Master of St Mark's College, John Bannon had, of course, for 8 years had his office, as I do today, in this, the former home of Sir John Downer. In the preface to Supreme Federalist, John Bannon particularly thanked, and I quote, Professor John Williams of Adelaide University, always a generous provider of references and inspiration, unquote. John Williams is widely known as a most distinguished constitutional scholar. No one is better equipped than John Williams to answer the question posed in the title of this oration. His 1,288-page volume, The Australian Constitution, A Documentary History, was published in 2005 and is an utterly central reference point for any research on the process by which the Australian Constitution came into being. The acknowledgements in that grand volume include thanks to John Bannon, amongst others, for reading and commenting on parts of it with, and I quote, good humour and keen eyes. Amongst many other distinctions, John Williams is also the Dame Roma Mitchell Professor of Law, Executive Dean of the Faculty of the Professions and Acting Provost of the University of Adelaide, with which university this college has been affiliated since 1924. In honouring the memory of John Bannon, there could be no more fitting topic than South Australia and the Constitution. There could be no more fitting Bannon orator than his friend and fellow constitutional scholar, John Williams. And there could be no more fitting place from which to give the oration than Downer House. Ladies and gentlemen, please join me in welcoming Professor John Williams.
Chair of the Board, Board members, the Head of College, Professor, Angela Bannon, Victoria Bannon, members of the Bannon family, alumni and students, colleagues and friends. It is indeed a humbling honour to be asked to present the second J C Bannon Oration. Given at this oration at St Mark's adds to the significance of the occasion in a number of ways. For a constitutional lawyer, physical proximity to the drafter's pen, or where that drafter's pen may have crafted terms and phrases of the founding document, is resonant. As John Bannon noted in his biography, his excellent biography of Sir John Downer, there are many advantages for Barton, Richard O'Connor and Downer assembling in this place. It was seen to be a more comfortable surroundings for Sir John's house in Pennington Terrace. The link to a South Australian history is only amplified by the fact that John Bannon was the seventh Master of St Mark's. In that role, John not only advanced the college and the study of South Australia and political history and social history, the college and the academy owes him much. Before taking up my theme of this lecture, I'd like to say a few fumbling words about John Bannon. I will not repeat his many achievements associated with John's political career. It is not that they are overlooked, but rather they predate my first encounter. A cherished friendship with John Bannon sprang from a shared interest in Federation history and constitutional law. My first encounter was through that most collegial of interactions a senior researcher guiding a novice in the direction of an unexplored archive or text. John was a meticulous and generous mentor and was always quick to alert me to his latest find or a potential nugget for my own research. It is this side of John's character that I know many researchers have also experienced. I've always felt that if public service had not claimed him, John Bannon would have forged a career in the Academy as one of Australia's great leading historians of Australian political history. He was a forensic researcher who appreciated the complex motivations and the shifting context that confronted society he studied. In preparing this lecture, it has been a distinct pleasure for me to re-engage with much of John's splendid scholarship. South Australia exceptionalism. The focus of this oration is the contribution of South Australia has made to the design and development of the Australian federal system. It is fitting that the topic intersects with John's works, both scholarly and professional. I will limit the scope of this paper to deal with constitutional history and law. Even within those broad parameters, it will be argued that South Australia has made a remarkable contribution. However, before attempting to marshal the material to develop an argument, there is one perennial proposition to be parried. That is the matter of South Australian exceptionalism. Within any provincial histories, there is a constant flickering light, and that is the question of whether there is something different or even unique in the circumstances or situation of a local polity that marks it out from the rest. Proponents of the argument tend to point to the numerous firsts that the evidence, which is evident in our history. They note that there is an evolution of attitude or institutions that can be found in clear delineation from the norm. Rightly, others ask whether this amounts to exceptionalism or just a mere deviation from the standard, a variation on an existing theme. Historians of South Australia have confronted this question since Douglas Pike famously characterised the framers' search for liberty and respectability as a quest for a paradise of descent. Robert Dare has summarised it as, quote, historians of South Australia have asked one question above all: how is South Australia different? Having summarised the various manifestations of the theme, Dare said, in asserting an exceptionalism, South Australia has lost its place in the national narrative. Arguably, this proposition is echoed in John Hirst's conclusion that in joining the Federation, South Australia compromised its superior position as an Australian colony, free from the convict taint. It was not tainted by association. Indeed, Hirst concluded that the trajectory of South Australian history began as a distinct colony and ended as a smaller state. Such a conclusion, while rightly highlighting the distinct contribution of South Australia, on the one hand, tends to diminish its role in the emerging state. In this paper, I want to add to that exceptionalism account, but by doing so, place South Australia not a pace or two apart from the national story, but rather integral to a component of it. So let me outline where we're going. In exploring the unique South Australian contribution of Australian Constitution, it is this development I pose myself this overarching question: was the contribution one of mere provincialism, or was there something substantive that marked it out from the rest? In other words, was South Australia projecting something beyond the protectionism, the defensiveness of a small community? This paper will assess this question by relation to South Australia from three perspectives: design, content and development. Each of these perspectives is integral, but the last is necessarily often in the hands of others, and in the case of constitutional development, the High Court of Australia. So turning to design. The design of the Australian Constitution is a complex story, and it belies the text that covered the 128 sections and the covering clauses in the document. In seeking to draft a constitution for the continent, Australians had to first think of themselves as Australians. The successful moves towards federation can be found in the various colonial conferences from the 1850s onwards, and South Australia was always a participant of some note in that, but we were raising the issues that were perennial issues: elimination of tariffs, customs imposed duties, how to make a frictionless border between the other colonies. While vital and practical steps along the road of federation, these early conferences lacked a popular sentiment that would sustain the final push through the 1890s. What is evident in South Australia's desire to be at the forefront of that movement? As a small province, South Australia had much to gain from a closely calibrated union. One of the striking elements of the Federation decade was the emergence of an Australian sensibility in its culture and in its politics. The establishment of federal leagues and associations supported the move for Australians to see themselves as themselves. The South Australian Art Gallery is a magnificent colonial collection, is testament to an emergent Australian responsiveness to the spirit of place. Tom Roberts' A Breakaway not only captures an energy and light of the Australian landscape, it has within it a confidence that Australia will move and strike out of its own motion. Such an approach to Australian nationalism would mark Roberts out for the obvious picture of the big picture. A cursory look at Australian art and literature of the 1890s highlights the aspiration of becoming a Commonwealth. While not wishing to overly romanticise the drafting of the Australian Constitution, we can see there are choices to be made, and often that choice was between an idealised home being on the other side of the globe and the practical reality of Australia creating its own stories and myths. Henry Lawson starkly put it as a choice between the old dead tree and the young tree green. The conferences and conventions from Melbourne in 1890 to London in 1900 framed the Federation decade, and South Australia was a critical and unwavering voice. The 1891 Federal Convention was held in Sydney and proved to be very instructive for South Australia to move the movement. South Australia entered the federal debate with some established things that it wished to advance and protect. Its access to the eastern states for its product, including its wine. It wanted a frictionless border. It wanted to solve the management of the Murray River. Who should control this? It also wanted to have standardisation of the railways, and it also wanted to be free of its Northern Territory, often known as the Northern Territory. South Australia's Parliament selected its delegates in 1891. There was Richard Chaffey Baker, John Gordon, John Bray, John Coburn, John Downer, a lot of Johns, Charles Cameron Speakson and Thomas Playford. The Kingston Baker, whose personal enmity was to rise as a result of an abortive attempt of a duel in Victoria Square in 1992, did much to prepare the other delegates for the adventure of federation. Baker had produced his manual on the reference of authorities, and Kingston his own draft of the Constitution. Kingston's draft of the Constitution, in anticipation of federation, had many of the normal tendencies one would expect in a draft constitution. But two aspects I just draw to your attention and underline his radical approach. He put in it a referendum provision that bills that failed between the two houses could be put to referendum of 20,000 persons to veto them or bring them back. More importantly, for this time, he suggested that each colony, quote, shall elect for a period of 5 years by the votes of the persons of those entitled to vote, the governor. He had an elected governor in the first of his draft constitutions. The federal parliament would be given under his constitution not only power to deal with the River Murray, but power to deal with industrial relations, two issues which were fond and close to his heart. In Sydney in 1891, the South Australians supported a number of key measures which found their way into the Constitution. The relationship between the Senate and the House, especially over money bills, and the compromise would be put forward by Playford, whereby the Senate could only make suggestions to the House and proposed amendments. Coburn advocated for universal suffrage of all electors, including the preservation of the rights of Aborigines. Downer remained an advocate for a powerful Senate, and Gordon made the case for an approach to interstate arbitration of disputes on the river. The 1891 Convention is famous for completing the task of drafting a constitution, but the draft would inevitably be the starting point for all future deliberations, including those here in 1897. But Australia didn't federate in 1892, and the answer to that can be put down to the end of the long economic boom, the intransigence of New South Wales, inherent instability of colonial parliaments during that time, and the momentum and focus were in short supply. The interregnum between 1891 and 1897 was an opportunity for critical intervention to frame the final constitution. There was a rise of popular movements around federation, though, as Bannon interestingly said, not here in South Australia, where the case had already been made. The next influential moment with the revival of the federation movement would be distinctly South Australian. The failure of 1891 convention concluded with the union was part due to a lack of procedural certainty. There was no enabling acts, there was no what do we do next. And Kingston was pivotal to drafting that enabling act, making sure that every step from the drafting of the Constitution to its final enactment would be designed. Kingston was one of the great drafters of his time. He also moved, as the Premier of South Australia, fast to lock in the agreement to continue, pushing forward legislation through South Australia to get the process on. The passage of the Act of enabling the drafting of the Constitution was yet one of the more obvious firsts for South Australia. When the male candidates for the constitutional conventions put themselves forward for consideration, they were joined by the formidable Catherine Helen Spence. Having granted women the right to vote in 1894, Spence duly exercised her right. She ran on the theme of effective voting, a form of proportional representation, known here in South Australia as the Hare-Spence system, in Tasmania known as the Hare-Clark system, and received considerable interest in her campaign. She finished a credible 22 in a field of 33. Elected in order in 1897 were Kingston, Holder, Coburn, Chafee Baker, Gordon, Simon, Downer, Howell and Solomon. Alfred Deakin, who watched and dissected the strengths and limitations of his colleagues for the benefit of his diary, expressed his assessment of the 10 South Australians in remarkably positive terms. He said, measured all round ability, the South Australian delegate was undoubtedly the strongest. What confounded the delegates, of course, was the sneering attitude about where the 1897 convention should be held. Kingston had successfully lobbied and extracted agreement from the smaller states of Tasmania and Western Australia that it should be held here in Adelaide. The eastern colonies were not amused. Deakin summarised the feeling in what he described as an underground treaty between the small colonies. He said, a stay in Melbourne was looked forward to with pleasurable anticipation, but in Adelaide, the city of churches, well, it was quite a different matter. The colonial conferences we met here in Adelaide in March to April 1897, the 10 South Australians would be joined by delegations from New South Wales, Victoria, Tasmania, Western Australia. Queensland had failed to rejoin the federal fold. The South Australians would play a prominent role during this convention. Kingston would be made the president of the convention, Baker the chair of its committees, and Josiah Simon the chair of the Judiciary Committee, positions they would hold throughout the rest. So having looked at that process, let's look at the content. What did South Australians do? The impact of South Australia on the overall shape and content of the Australian Constitution. Now, this may be viewed for a number of lenses. The following part of the paper highlights those sections of the Australian Constitution where South Australia had authorial oversight. Also, as will be demonstrated, the longevity of some of these contributions may have not been proved as significant as they thought. However, their contribution should not be underestimated. Let's start with the blessing of Almighty God. Whereas the people of New South Wales, Victoria, South Australia, Queensland and Tasmania humbly relying on their blessing of the Almighty God. It's in the preamble of our Constitution. And on the 2nd of March 1897, Patrick Glynn confided to his diary that, today I have succeeded in getting the words humbly relying on the blessing of the Almighty God inserted into the preamble. It was chiefly intended to gain greater support from a larger number of voters who believed in the efficacy for good of this formal act of reverence and faith. It's a pretty dry little entry into a diary, but he got God in the Constitution. For Glynn, this was successful action in advancing the cause of recognition was both a personal triumph and a political necessity. The invocation of the Almighty in the Constitution proved an insight into the place of faith at the time and the vexed decision of bringing God into the political realm. The push to include God in the Constitution as in the preamble commenced here in the City of Churches. And towards the end of the convention, Glynn moved for his amendment for the imposition of God. Now, Glynn's contribution was met with mixed results. Douglas from Tasmania described his contribution as a sermon and suggested it should be left alone. Barton, sensing the divisive nature, hoped that Glynn would withdraw. Others pressed Glynn not to push his motion. Ultimately, as we know, he would be a triumph for Glynn. Now, Glynn's ultimate triumph would motivate another Irish lawyer, H.B. Higgins, from Victoria, to engage in a sustained campaign to put Section 116 in the Constitution. For Higgins, the inclusion of a reference to the Almighty left open what he describes as the tyrannical prospects of the Commonwealth being able to tell what day we shall observe religious reasons and what days we shall not. As we will see, Glynn's effort also made Section 116 an important role which South Australia would have. Section 41, the right to vote. The fact that South Australians had extended its franchise to women in 94 provided particular concern for some members of other colonies when the delegates met to draft the Constitution. In particular, would South Australia example mean that the Commonwealth would commence with universal franchise? For South Australian delegates, there was an overarching imperative to defend a right in the draft Constitution lest the newly enfranchised women of South Australia would be denied that right when the Commonwealth passed its electoral laws. During the consideration, the qualification of the electors of 1897 convention in Adelaide, Frederick Holder proposed the insertion of a section that would have dramatically extended the franchise. Holder suggested, every man and woman of full age of 21 whose name has been registered as an elector for at least 6 months shall be an elector. His reasoning was quite simple. We wish to give effect to the desire that many of us cherish that women as well as men shall be recognised as electors in this great Commonwealth. Now, the argument against such a bold move was familiar to the South Australians. Wise from New South Wales suggested that the South Australian experiment should be allowed to run its course before the rest had to adopt it. The approach proposed to Holder was said to be dangerous to the cause of federation. Douglas from Tasmania suggested that, quote, he had not found a single woman yet who was anxious for the franchise. And during the debate towards the end of the latter part of the convention, Barton raised a new concern that the states able to determine the Commonwealth franchise, he asked what would happen if, quote, if the suffrage was extended to females of 18 or 19 of age or to certain undesirable classes. Holder was willing to concede the federal argument, but he was not willing to concede much more. And Section 41 is a testament to his actions and the role of South Australian women. A side note to Section 41 is the implications it had for Section 128, the amending provision of our Constitution. With South Australia having universal suffrage, there remained the remote prospect that South Australia would have twice the vote if an amendment of the Constitution was proposed before the Commonwealth had given everybody, all women, the vote. Barton was alive to this issue and he noted that the amendment was needed. One suggestion he noted was to prevent ballot papers on these questions being given to women. If you went down to the referendum, women wouldn't get the ballot. Now, an unreality broke out during this stage of the convention debate. Alfred Jenkins suggested that it might have two ballots boxes in South Australia, one marked male and the other one marked female. Fellow Victorian George Turner rebuked Deakin, suggesting that will not do. That would make sure there'd be mistakes. Have different coloured papers. Now, thankfully, no one went so far to recommend what coloured papers men and what coloured ballot papers females should have. In the end, the convention solved the issue by using what Isaac described as a rough and ready solution. The South Australian votes would be divided in half. Today, Section 128 continues to honour the rough and ready solution of the troublesome South Australians. I'll briefly talk about old age pensions, Section 5123. James Howe, the Scottish-born immigrant to South Australia who came here in 1853, aged 17, became a mounted policeman, a publican, a farmer, but he also, a conservative by inclination, he had a genuine concern for the poor and suggested that the Australian Constitution should have a reference to the old age pensions and those dealing old age pensions. Now, unfortunately, Howe was wholly unsuccessful in getting this up in 1897, but he persisted 3 times to put this into our Constitution. I don't think it should be underestimated that this was a remarkable effort, given that today we know that the role of the state and pensions and welfare, maternity pensions, students' allowances derive from this very small act by One South Australia and is the hallmark of the modern welfare state. Conciliation and arbitration, Section 5135. Quick and Garron, the great authors of the tome on the Australian Constitution, said this pioneering idea can be put down to Kingston, the South Australian Premier. At the 1891 convention, Kingston said that the industrial upheavals here in South Australia and other places meant that we must create a means by which the state would arbitrate between the interests of capital and labour. The initial foray into industrial regulation was met with both technical objections and a deeper matter of principle. For some, the question is whether it was a court that was the appropriate venue for this relief. Others took a different view. The carriage of this would ultimately fall to Higgins, but the clause would go on to become an essential feature between the settlement between industrial relations in Australia and one we will return. Interesting enough, it divided the South Australians, one of the few provisions it did. Conservatives such as Downer, Glynn and Simon said it was a federal issue and should be left to the states. Others like Higgins, Howe, Kingston and Coburn and Holder said it was a national issue. As one said, like bushfires and rabbits, industrial disputes don't recognise boundaries. I won't touch on the appellate jurisdiction of the High Court, but it's one of some interest and some note for those. Let me move to the big issue for South Australia. The Commonwealth shall not by any laws or regulation of trade or commerce abridge the rights of a state or its residents therein to reasonable use of the waters of the rivers for conservation and irrigation. If there was one matter that unified the South Australian delegates more than any, it was the question of the river and its regulation. The river question was described, would be one of those which one constitutional historian, John Lennose, described as long and tangled debate. The essence of the dispute was undeniably made out in the text of the Constitution itself. It fell into 3 seemingly intractable issues: of the use of the river for trade, which meant navigation for South Australia, conservation and irrigation. Trade and commerce for South Australians was the ability to access the river as an inland highway to move goods to the east. All communities along the river had an interest in the conservation of water and irrigation for production of food and fabric. The notion of sharing was rarely in dispute. Trust, on the other hand, was rarely in abundance. For the South Australians at the bottom of the river, the prospect of limited control or a forum for which it could be advanced their legitimate concern was the catalyst for an unifying action. As noted, Kingston in 1897 had tried to fix the rights in the Commonwealth Constitution. Gordon was the leading protagonist for South Australia during the debates. During the first of many interventions on the question, he forthrightly informed the gathering that he rejected any argument that the river was solely owned by those territories it ran through. Gordon would carry the debate by reference to international law, to previous commissions, to riparian rights, to appeals to a unification of the colonies. He was joined by Glyn, Downer, Simon and Kingston. The river debate would run for months through Adelaide and Melbourne, sitting of the conventions. Amendments would be proposed, withdrawn, rejected. South Australia maintained its proposition that the river needed to be beyond the control of each state and rest with a national authority. The upstream colonies argued that it was possible for South Australia to rely on them to ensure adequate water to flow. Even if South Australia would have the best of the argument, they did not have politics running in their direction. The prospect of diminishing support for federation in New South Wales and Victoria meant that South Australia would be fighting an uphill battle. Alfred Deakin candidly admitted during the debate that South Australia had made a gallant attack, that it had marshalled their arguments with ability, agility, resourcefulness and ingenuity. Despite this, he told them that he would be voting not upon the merits of the case, but upon the practical eye of the success of the Federation in the great colony of New South Wales. South Australia would be sold down the river. Ultimately, this lacklustre compromise would be agreed. With a number of running against them, South Australia cajoled or shamed an amendment out of George Reid, the New South Wales Premier, who proposed a limitation on trade and commerce power. It was left to Downer to make one last amendment on behalf of South Australia. He suggested that the limit upon which qualified the insertion of the word reasonable before the word use, and it was agreed on the voices. These examples just highlight some particular interests of South Australia that made their way into the Constitution. However, it should not be seen as the only aspect of their actions. The South Australian delegates advanced compromises, put forward matters of principle. I'd now like to turn to developments. Rapid and dramatic developments in the governing compact is in natural tension with the idea of a written constitution. By their very nature, written constitutions are designed to constrain. The past seeks, to a certain degree, to bind the future. Having debated and reduced their hard-fought compromises to a honed text, many of the framers were keen to hold it in place. John Donaldson, the Queensland delegate at 1891, said, "For my part, I wish to make it an amendment of the Constitution as difficult as possible." Such an extreme view was not held by most of the framers, but there were essentially three methods for amendment or evolution. The first was through the formal mechanism of section 128, and that section was closely scrutinised by the framers. Alfred Deakin, the second method was the one of constitutional innovation through the use of interpretation. The High Court of Australia was charged to make methodical changes through interpretation of the words. Andrew Inglis Clark famously in Tasmania said that the Constitution should be made a living force. Alfred Deakin, during the 1920 Judiciary Bill, said that the nation grows, it lives, it expands, and the changing circumstances it needs to alter and the problems that are presented with new faces. The organ of national life that preserves the union, yet able from time to time to transfuse into the living blood of the present, is the judiciary. Now, notwithstanding the controversial it may be, the third way which was seen to change the Constitution was to go back to its original source of authority. Quick and Garran noted that it was possible to go to the Imperial Parliament to change our Constitution in what he described as serious emergency. Thankfully, that one is lost. The South Australian record in formal constitutional amendment or plebiscite largely mirrors that of the other states. It unsuccessfully in 1911 and 13 referended extended Commonwealth powers over arbitration industrial matters. It voted with Queensland and West Australia on that measures. With only Western Australia did it vote to extend the Chifley's post-war reconstruction in 1944. It voted with New South Wales and Victoria to defeat Sir Robert Menzies' 1951 Communist Party Dissolution Act. In doing so, it cut from the normal thing of the small states sticking together and became the swing state. The only dramatic vote where South Australia stood out from other states was 1977, during the plebiscite on the national anthem. The other states voted, supported strongly Advance Australia Fair. In South Australia, it finished second to Song of Australia, which got 34% of the vote. By contrast, Song of Australia got 6% of the vote in New South Wales. I think it was our local person made good. In South Australia, has not dramatically shaped the Constitution through formal questions or through input. First question about the interpretation of the Constitution starts with the proposition, does it make any sense to ask whether someone is a member of the High Court, their state of origin is important? Now, South Australia has not been able to enjoy that question because South Australia has never had a member of the High Court and so has not had that opportunity. However, it's not the case that South Australia has been ignored in the appointment to the High Court. Sir Samuel Way, who described the High Court as much needed as the fifth wheel on a coach, proprietely declined Alfred Deakin's offer in 1906 to join the High Court, citing, amongst other reasons, the long and frequent journeys and being forced to be separated from his library. In 1913, Sir John Gordon, a member of the Supreme Court of South Australia, declined Billy Hughes' offer to replace Richard O'Connor, who died in 1912. Citing ill health, he urged Hughes not to appoint fellow South Australian Patrick Glynn, who he described as a good fellow but ineffectual. He went on to say that, quote, his mental output always seems to me to resemble scrambled eggs. Wholesome enough, but messy. There has been, since 1903, many South Australians who had a good claim for membership of Australia's pinnacle court. Regrettably, their abundance in legal acumen has not been twinned with their support in the federal cabinet. What impact has the absence to the direction of the court and its interpretation of Australian law had with no South Australian? What impact? Sir Samuel Way in 1903 noted that the possible impact of the High Court dominated by the eastern states. He mused to his friend, what chance South Australia have in any litigation to prevent the waters of the Murray River being diverted with a majority of New South Wales or Victorian judges on the bench? I'll just let that hang. If South Australia has not had any opportunity to consider the interpretation of the Constitution through constitutional developments, it has through litigation and through other activities. And this is what I'd like to now judge. There's three ways of looking at this. First of all, I'd like to review the High Court's interpretation of those sections that the South Australians put into the Constitution. So, as you recall, the blessing of Almighty God, section 41, the writing votes, and the water. So, as I reminded you, the invocation of the Almighty by Sir Patrick Glynn in the preamble proved to be an invitation for a counterbalancing provision in the Constitution, section 116. Litigation in relation to 116 has been relatively limited since 1903. Arguably the most significant case that took place in Sturt Street in the west of the city. On the 17th of January 1941, the police, acting in accordance with the National Security Subversive Association regulation, raided and seized Kingdom Hall. A week before, in January 1941, 6 cars deposited military police, soldiers, plainclothes police on the same premises that housed the radio station 5KA and inspected literature and documents held by the station. The Adelaide Company of Jehovah's Witnesses were declared to be an organisation seeking to destruct the defence of the Commonwealth and the prosecution of the war. When the case came before the High Court in 1943, the question of freedom of religion was at the fore, and unfortunately the High Court took the view that the community safety rather than freedom of religion would sustain. A South Australian case. The strongest defence of Section 41, the right to vote, for many South Australian delegates had fought so hard, was also a South Australian case in 1972. One of the applicants was Susan King, the daughter of the then Attorney-General of South Australia, Len King, who brought the case after she was denied the right to vote. She was 18-year-old and was eligible to vote in South Australia. At the time, the Commonwealth was 21. She was denied that right on the basis that Section 41 was a transitional provision and ultimately did not protect the right to vote. Ironically, the very thing the South Australians felt that they were protecting. If I was to look at old age pensions, I've made the case before that Section 5123 became the hallmark of the welfare state. And in its course, it became the early 20th century South Australia and the cases moved to women's pensions, unemployment benefits. It was tested in 1945 in the Father Suku benefits case and was held to be outlawing. I'll pass by conciliation and arbitration, but just to note that with the expansion of the work choices case in 2005, this whole section, the one that the High Court had spent decades on, became, as Justice Kirby said, a hypothesis in futility. It no longer is now ultimately a dead letter. Turning to Section 100, the rivers. One of the many incongruities relating to the rivers question was the fact that South Australia was not the scene of the first great constitutional contest. During the long debate on the question in 1898 convention, the Tasmanian Premier, Edward Braddon, cast himself as a delegate with an objective view in the contest between South Australia and the upstream states. He said, "I think the responsibility that rests with the representative of Western Australia and Tasmania is possibly weightier than the rest of the other representatives, insomuch as we are wholly unconcerned with the matter. We have no personal interest to serve, and therefore we can be recognised as the arbiter of this question." Now, despite Braddon's lofty ambition, in 1983, Tasmanians were wholly concerned about what authority the Commonwealth or the state had over a river, the Gordon River. The Tasmanian Dams case was the first major test which the South Australians had attempted to craft into the Constitution. I won't bore you with the details, but it's suffice to say it didn't work, and that the Commonwealth was free to pass laws, some would say for the good reason, to protect the Gordon below Franklin River, and Section 100 stood in no way. The second lens by which we can look through whether South Australia has been influential in the direction of Australian law and the High Court can be through strategic or non-strategic litigation. As an apex court, the High Court is available to litigants with meritorious claims. And in this category, there are many famous and infamous litigants who have tried to shape the trajectory of Australian law. By far the most vexatious South Australian was Frederick Alexander James, the berry packer and dealer in fruit. On the 6th of May 1927, his offices were raided at 7:30 and 350 tonnes of dried fruit were taken and seized. There was a quota system in operation. He was selling above quota. He successfully argued that South Australian Act was contrary to Section 92 of the Constitution. His victory was made all the more memorable given that South Australia had briefed Owen Dixon KC and his junior in that case was Robert Menzies. Flushed with this partial success, James would go on the offensive to take on the Commonwealth and the State and the High Court and the Privy Council on no less than 7 occasions between 1937 and 1939, all in the efforts to sell dried fruit into Victoria. Other residents of South Australia have tested the meaning of the Constitution and found themselves amidst what would be described as leading cases. Polovjukovic and the Commonwealth tested the constitutional validities of the War Crimes Act and whether Australia could take a role in prosecuting offences against humanity between 1939 and 1945. A resident, and I use that phrase in inverted commas, of South Australia, though without the rights one associates with that status, was Mr. Almar al-Khatib, a stateless Palestinian born in Kuwait. In 2001, Mr. al-Khatib was refused a protection visa to remain in Australia. However, his wish to leave Australia was unsuccessfully due to the necessity of international cooperation. As a stateless person, he had nowhere to go. He faced the prospect of indefinite detention. Could such a situation be allowed by the executive imposing a form of punishment contrary to the separation of powers? It wasn't punishment, but they could be detained indefinitely. Both cases are far-reaching constitutional implications and both came from South Australia. In terms of South Australian, there's been litigants who have helped define our place in the polity. A literal defining moment for South Australia came in 1911 when South Australia sued Victoria in the High Court for a 2-mile strip of land along the 141st meridian. A survey error in 1840s meant that Victoria had encroached on South Australia territory. Lacking an effective tribunal, a dispute between the colonies rumbled on for the next 60 years until they could find a venue. The High Court, and in the High Court, South Australia found the right venue. Unfortunately, we asked the wrong question. As the High Court said, this was in fact a political agreement, not a legal one. This was not the last time that South Australia would find itself in the political or policy disagreement in enforcing its legal rights. South Australia surrendered its Northern Territory to the Commonwealth in 1907 and brought with it an understanding that the Commonwealth will build a railway from Darwin, Port of Darwin, to the southern border. In furtherance of that ambition, South Australia and the Commonwealth entered into agreement to have a national railway gauge in 1949. In 1961, South Australia grew weary of the lack of progress and decided to take the matter to the High Court. Yet again, the nature of the agreement fell short of enforceable rights. As Justice McTiernan starkly put it, the promise on either side is a political in nature, and both parties would understand the time of that agreement was made. That was a time of true promises but no action. So the survey across, and I won't bore you with the rest, the survey across South Australia's contribution to the jurisprudence of Australian Constitution is chronicled in the pages of the Commonwealth law reports. They range from attempts to regulate trade through Castlemaine Tuies and the imposition of levies in H.E. Slee. The state would lead challenges to the uniform tax legislation in the midpoint of the Second World War. In the 2000s, the state government would be locked in a law and order auction with outlawed motorcycle gangs would be its chief focus. These exchanges required the High Court to consider the limits of state parliamentary authority in Tatani and K generation. South Australian names, places and individuals have provided the vehicle for which South Australia has considered the fundamental questions of the Constitution and its meaning. I want to pause on one last case, and it's Cole and Whitfield in 1998, because it's exemplary of a matter. The case involved, as many would know, the export of South Australian crayfish into Tasmania. The crayfish that, upon the importation into South Australia, are undersized and contrary to the fishing regulation. A very minor point. The case arguably is one of the most significant in the High Court's history, and it owes much to the advocacy of two South Australians, the then Solicitor General Sir John Doyle QC and Brad Selway. They mined the unrestricted, or till that point restricted constitutional debates and unlocked a meaning of Section 92 of the Constitution. The unanimous decision of the High Court found a way to sweep away 70 years of poor jurisprudence and uncertainty about local protection. And it was laudable in that case and in many cases that the South Australian argument was the defining argument, especially when it was made by those and other South Australian advocates. So in conclusion, in 1901, South Australian population was approximately 350,000. At the 1899 referendum to consider the fate of this Constitution Bill, those who voted in favour were 65,000 and against 17,000. This was a non-compulsory vote. These figures serve to highlight the challenges that confront a small state who could not readily exert economic or political influence. Rather, their call was to first principles, guile and persuasion was the order of the day. South Australia, by any measure, has made a disproportionate impact on the final draft of the Constitution. It can point to a number of key provisions that address significant matters. However, it did tend to rise above the provincial ruck to appeal to common interests of the coming Commonwealth. The state, in the terms of constitutional development, can point to a series of initiatives that have left an enduring impact on the direction of travel. South Australia owes it to the Commonwealth to maintain its role as the instigator of reform, the supplier of both novel and bold interpretations. That has been the tradition. Long may it be so. Thank you.
Thank you so much, John, for such an engaging and amusing as well as erudite answer to the question of whether South Australia's contribution to the Australian Constitution has been a mere provincial contribution. We now know that it has not been a mere provincial contribution. In your discussion of South Australia's contribution to the design process in the 1890s, the content of the Constitution as it was settled in that process, and in the development of the Constitution since then, you have given us the benefit of your truly encyclopedic knowledge of this topic. Generously also acknowledging John Bannon's significant scholarship in this field. So your J C Bannon Oration is truly fitting to the memory of John Bannon, I think superbly combining academic quality with wider appeal, and we are all most grateful to you. As a very small token of our gratitude, I'd ask you to accept this gift. You'll never guess what it is.
South Australia?
It is South Australia, of course. Now, I'm delighted to say that in coming weeks, John's text will be published as a booklet as well as online, and we will be in touch with those here in Downer House and those online with details of how to receive a copy. Before we conclude, as well as again thanking John Williams, I'd also like to thank others who have made this oration possible. In particular, Angela Bannon and Chris Gent, who helped to guide the planning of the oration both graciously and wisely. Generous donors for financial support for the oration, more of which is warmly welcomed. Pamela Thompson in the Provost's office for her help. My indefatigable colleague Carol Atkinson for coordinating this event so well. Old collegian Alex Haddon for mastering the IT, which we've needed to be online, and other staff and students who have helped with tonight, including Katie Morgan for photography. And may I conclude with thanks to those who've been with us both here in Downer House and in much larger numbers online. Thank you for your interest. Please join us next year for the 2022 J C Bannon Oration. Thank you and good night.